In Minnesota DWI cases, blood testing is far less common than breath testing. However, it is worth mentioning it because there are certain circumstances where an officer may take your blood in a DWI case when you're arrested in Minnesota. In most cases, the officer will request a breath test rather than a blood test. One major exception is that if you are taken to a hospital or other medical facility and blood is drawn because you were in an accident or you are sick for some other reason, an officer in Minnesota may request part of that blood to be tested for alcohol level. It is not required in Minnesota that you actually consent to having that blood taken or that you even know about that blood being taken, and it can be used against you. Another circumstance in which an officer may attempt to get a blood draw from you rather than a breath test is if you allegedly refuse to take a breath test. It goes something like this. You get taken to the station, the police officer offers you to take a breath test, usually on a data master machine. You either say no, or you, from the officer's view, play games and don't provide an adequate sample for the officer to get a reading that they can use against you to charge you and prosecute you in court. In that case, the officer may get a warrant to take your blood, and if the officer does get that warrant, you have to submit to that blood test, and if you don't submit, they can charge you with a serious felony of obstruction. An officer may, once they have a warrant, use reasonable force to get that blood. So most people, when an officer has a warrant, end up cooperating. All things being equal, blood testing is far more precise than breath testing. However, blood analysis is not foolproof, and in Minnesota DWI cases, there are serious potential sources of error. The number of sources is virtually unlimited and really depends on the knowledge, diligence, and creativity of your DWI attorney. But some common ones include mislabeling of the blood so that it doesn't, it appears to be yours, but it really isn't. Chain of custody issues where the blood is taken from you but then disappears for a while before it ends up in the lab to be analyzed. The blood can be compromised in other ways, such as being exposed to heat, not being captured in the proper tubes, being contaminated by outside sources, whether intentionally or accidentally, that can be injected, or can be something so simple and nearly undetectable as microbes getting into a poorly sealed tube. Flawed test equipment can also produce bad results. Much of the Minnesota DWI blood testing procedure is automated in that a machine basically does the work once the technician sets it up. And if the machine's not properly functioning, the results can either be introduced into the machine incorrectly, or they can be interpreted by the machine incorrectly. There are also a number of technical errors and Scrivener's errors that can occur on the part of the technician that can mess up not only your test, but all the other tests that are analyzed at the same time as yours. Because of these potential sources of error, it's important that if you are charged with a Minnesota DWI, and if you think that you might be innocent, to have an attorney investigate, because the attorney may discover that there are serious errors once they get the data back from the laboratory. There is so much to be learned about DWI blood testing, both in Minnesota cases and in general. To start to learn more, visit DUIattorney.com/Minnesota/MN-evidence, and also visit the general pages that go over in more detail blood testing concerns and procedures and so forth on DUIattorney.com.